The Associate Director of the Children and Youth Law Clinic at the University of Miami, not in Miami, in Coral Gables, Florida, oddly named. I am also a registry attorney, so I'm on the wheel with the rest of you guys. And before that, I was a guardian ad litem, I guess we were calling them senior program attorneys at the time. We've changed the names every other day. So thank you so much for coming. Somebody walked through the door and said, "Is this where I learned to bill correctly?" And I was like, I don't know, right? I have no idea. We're going to talk about lots of things. Billing will be in here, but this is not a training on how to bill. There is a billing section. This is a training on how to put together a team to enhance your advocacy. So just kind of keep that in mind. That is our goal, and to talk about the ethical implications of that and how to do it in an effective way, and then how to bill for it. So with that said, I want to see kind of what team we have in the room today. So if you are an attorney for children, do you mind raising your hand just so I can see who you are? Hello, all you guys. All right, thank you. If you're a GAL attorney and or other person, hello. Hi, I got a couple. Hi, all right. Anybody I didn't get categorically? Hello, and who are you? JAC. Jack, the JAC is here to keep me honest. All right. I will tell you.
Next year she has to do her own.
Which would be really helpful, right?
This is actually a trick. Robert, give it the
There you go. Happily. We will talk about the fact that I'm going to call it JAC because that's what we call it in Miami, but the JAC, the Justice Administrative Commission, has a lot of trainings on their website. They have a lot of training. They have an overwhelming number of trainings on their website, which can make it kind of difficult, right? So we will talk about that, and I'll point you to a couple that are really useful for this topic. All right, so what are we trying to do here? Well, we're trying to continue to develop this thing called an attorney for children in Florida. Yes, there are attorneys for children all over the country, but in Florida we know that historically this has been a guardian ad litem best interest state. So building up this model and proving that it actually provides real results for kids is kind of a lifetime goal for a lot of us, right? And so one of the things we're going to be focusing on today is just a sheer amount of funding disparity between the kid on the case, right, and the institutional parties on the case. So you see here in this kind of slapdash diagram, our DCF has investigators, case managers, accountants. They've got 1 million people working for them, right? And then they pay dearly for that. They have CLS attorneys who are very experienced and generally really good prosecutors. They also have like this whole army of experts who are calling them on a daily basis to offer their services to them because they want a job, right? So DCF is DCF is hurting for resources, but not really in the litigation department, and especially not when compared to this other side of the pie, right? JAL program unfortunately hasn't been able to hit full representation yet, gets more money every year usually, but does also have a large amount of resources, right? The beauty of the model is that a large part of the advocacy gets done by a volunteer who is both the fact finder and your star witness, right? That's not free, right? Training that volunteer, monitoring that volunteer is not free. A lot of money gets spent doing that, but you have this fact finding volunteer, you've got an attorney, you've got a supervisor of some sort with either social work background or child welfare background that's providing guidance and support to keep everything on track. That's a great team, right? It's not a cheap team, it costs money. The child has the child, not usually the best investigator, definitely often not the best witness, right? Definitely not an expert on anything except usually their own life. That's what we say. The kids are usually the experts on their own life. The parents, similarly, right, come in with a huge credibility gap to begin with, right? So a parent testifying even about simple facts in their case come in at a huge credibility gap, right? So this presentation is aimed at those of you who represent kids, but the same presentation goes for anybody who represents parents as well, right? There's so much work that can be done to flesh out the team around the parent. We will talk more about that a little bit. All right, here is my plan. I do have a plan. I don't know if I'll be able to do it. I have thrown something from the internet over here to diagram that. So we're going to talk about ethics and roles. I'm going to show you a bunch of charts because I like charts. I'm going to talk about the team that we're going to try to put together and give you some ethical scenarios and kind of play through them a little bit and how it would work and kind of what the pitfalls and the benefits are. We are going to have a part toward the end on accessing JAC payment. Hopefully that will be useful, and I will have Q&A at the end. So if you feel like your question can wait to the end, if it's just kind of an off question, feel free to save it to the end. If I said something that didn't make sense, shoot up your hand and ask it really quickly, and I'll clarify whatever I need to clarify. So that's the plan. Good luck. All right, here we go. So kids. Kids don't even really get that many attorneys, right? So in 2016, there were approximately 17,237 kids who came into the child welfare system in Florida. In 2016, 942 kids got appointed attorneys. It's not the same population. We're showing scale here. So tons of kids come in. We're talking about a very small percentage of us doing this job running around right now. We would like to see it be more. So hopefully this presentation will inspire people to expand what they're doing already and invite their friends to do it as well. So, all right, the attorney, I love this, I love what it's called in the statute. You are an attorney for a dependent child with certain special needs. Don't go crazy, right? Certain special needs. All right, so they are, you probably know them by heart because you have to check them off on the order. Psych meds and the kid doesn't assent, right? Victim of human trafficking as defined in some statute somewhere. Developmental disabilities as defined in some statute somewhere. That one's a little strange sometimes how it gets used. Residential, being considered for a residential treatment center, right? Not actually in one, not anything. What does considered mean? We don't know. It's when the judge signs the order, right? And then the skilled nursing facilities. Is anybody handling a skilled nursing facility case? I have one. Two, okay.
There were only a few kids.
Exactly, yeah. Apparently there are still some, because I got two hands up. I didn't know they were out there. I just asked it on a whim. So I'm not going to be talking about nursing facilities that much because I personally have never handled one, but all of this applies just as equally to them. Okay, so this population of kids gets an attorney because the legislature has decided, well, one, that the attorney is supposed to provide this complete range of legal services, right, for these kids, but really the point is to address the kids' medical and related needs and the services and supports necessary for the child to live successfully in the community. What does that mean? Anything you want it to, literally, right? I have traveled the state and talked to people about this. Some people are like, oh, I don't want to do it because I don't want to do Medicaid appeals. Fine, find somebody who will do Medicaid appeals, right? This can be all kinds of things. So when your kid's a little kid and they need an APD application, it can be doing an APD fair hearing. Those things are really fun to do. When your client is 19 and facing an eviction, right? You got a client with a developmental disability trying to live in the community facing an eviction, handle the eviction if you want, or refer it out. Handle the eviction. We handle evictions. You can bill for that. So the idea is you are one of the champions for this kid to keep them living successfully in the community. Keep them out of jail, keep them out of programs, keep them out of everywhere you can. That's a noble goal. That is not easy to do. So what winds up happening is it turns out doing that, one part of that is the part I already showed you, right? The dependency part. You can only win so many battles in dependency court because dependency court only has so much jurisdiction. A lot of the other battles are around education, disability rights, community access, public benefits, immigration, because immigration status is a prerequisite for a lot of this other stuff, and then literally everything else you can think of that a disabled kid or a kid who's a victim of human trafficking or any of the other categories would fall victim to, you can be there for them under the statute, right? Which means later you can bring in experts to help you fight those fights. I put child support on there because I do actually handle child support cases for our clients who are adults. So they need child support to help raise their own kids so they themselves, right, don't lose their own kid, which would then spiral them out and then suddenly we would lose them. So all kinds of things, right? So the client is complicated. The client is not just a Chapter 39 client. This is distinctly different than the role of a parent's attorney, right? Regional council, by statute and funding and a lot of other things, sees its role as the Chapter 39 role. If you need something else, refer it out to another person, right? The appointments for parents in the child welfare system generally see it as just appointment for that case. We've had a lot of success viewing this as a holistic model, and I would encourage you to try your hand at it. It can be a lot of fun. All right, so I know there's a lot of kids attorneys in here, but I do want to go over the ethics of this a little bit because it helps ground us in some of the conversations later. So what is a kids attorney? what is an attorney, right? Attorneys have a lot of conflicting roles that they have to play. And I do this presentation for case managers every now and then because they need to know that we're not crazy, right? They need to know that there are actually rules that are regulating what we do, and that it's not how we would behave at a dinner party, but it is how we behave because it's the way we've been trained. Just like that, they behave strangely sometimes because they're social workers, right? So, yeah, we know. Conflicting roles. So you are both a counselor and an advocate, right? So you are privately telling your client, don't do that horrible thing you want to do, while publicly advocating for them to have the freedom to do the thing they want to do, right? It's a conflict, a tension. It makes you look crazy, right? You also have all kinds of obligations to other people, both the client, the court, third parties, the public. All the ethics rules have all of those things built into them. So you're constantly kind of battling that out, right? Your client wants to involve you in something that's not quite a crime, but it's a little shady. Well, you have an obligation to the court, you have an obligation to the public, you can't do that, you want to keep your bar license, et cetera, et cetera. So these things drive us nuts. Right? All attorneys owe all clients competence, diligence, communication, right? Confidentiality, loyalty, and a whole list of things. It's good to remember these because they're going to come up in a little bit. All lawyers owe courts, candor, meritorious claims. That's going to be the most important one for today's conversation. Fairness to opposing party will come up, and impartiality and decorum. Oh, and speediness. Right. All right. How does that apply to kids? Oh, that can't possibly apply to kids. Kids want to do all kinds of things. It applies to kids, right? Rule 4-1.14 is the client under a disability rule. We live in this rule. We live in it. What it says is that when you have a client under a disability, and the comments specifically list minority as an age, right, as a possible disability, when you work with a client under a disability, you are supposed to maintain as normal a relationship as possible with them. Right? Not put your ideas before theirs, not ignore them, not anything. You're supposed to do as much as possible what you would do with a client if they weren't under a disability. So the immediate example I always give is if your client was 35 years old, an adult, right, and spoke Spanish, and you don't speak Spanish, would you just, do whatever you want? No, that'd be crazy, and you would get disbarred, right? No, you get an interpreter, and you figure out what they want. When your kid is 35 years old and goes into a coma, is that like, yay, my client's in a coma, I can literally do whatever I want? No, absolutely not. No one would do that, right? You would get disbarred and probably arrested if it involved money, right? So what do? Well, you have two options. If they can't act in their interests, right, you can seek to have a guardian appointed. If if you're kind of in that weird gray area, you might be able to act as a guardian and do certain acts that are protective of your client. So if they go into the coma, they're only going to be in it for 2 weeks, and their house is on fire, can you put the fire out? Yes, right? Those types of things that protect them during the disability to kind of help them out. Now, as part of this, because you owe this client a duty of loyalty, are you just making up what you want to do? No, you're looking for objective messages from your client, conversations you've had in the past, to look back and say, what was their position? What was their position once upon a time? They love this house, they don't want to see it burn down, I'm going to save the house, right? So we're going to keep all this in mind because it's going to come up with your experts later, especially the social work experts, because they have a different view of things, and you're going to have interesting conversations with them. All right. I use this as well to help explain the difference between direct representation, which is, express wishes. I don't like that word. No lawyer does exactly what their client wants. You don't. No lawyer does that, right? You counsel them, you tell them it's a bad idea, you help them come up with a better solution. So express wishes doesn't really work for me. Direct representation, doing what lawyers do, does work for me. So in direct representation, when you're coming up with your plan, right, what your case is going to be, and we're going to talk about that in a second, you start with the client. You start with them, you investigate the facts, you consider the law, and then you work to move the client, the facts, the law, and everything else as close together as you can so that you can go before the court, right? Either at the end of the day, you bring the motion or whatever they want you to do, you convince them to change so they're doing something that's more reasonable, or you withdraw, right? So the client who wants something absolutely ridiculous, there comes a point where you play chicken with each other long enough, and eventually you just withdraw if it's that ridiculous, right? Best interest representation does it kind of in reverse. You start with the facts and you narrow down on what the best interest is under those given facts. You consider the child's wishes, you consider everything that's going on, and then you kind of assess what you think is best from that. So it kind of starts with facts. Interesting thing, and I have the benefit of having worked in a best interest office and now work as an attorney ad litem. It is a very different process. It's a very different process. The urgency of investigating new facts and developing cases out in a best interest model it feels significantly less because you're responding to what's on the ground already, right? Unless the best interest and the facts are just so out of skew, there's really no reason to create new evidence. You just respond to what's there. And that's kind of been reflective of, when I worked at the Guardian program, our litigation budget at that time was like $4, and we were not allowed to touch it. It had to be there every year because we could carry it over and collect interest, I guess. So it was no litigation budget at the Guardian program. When I was there, it may have expanded. I'm not speaking for now, right? What we were told to do was go out and convince somebody else that what you're saying is a good idea and get other people to spend money on it, which was very interesting, right? So,
litigation budget for attorneys, and you don't spend it all.
You don't spend it all? They don't really spend it? All right, Guardian ad litem attorneys, spend it. I'm getting messages from the top here. All right, good. I'm glad to know there is one. I'm glad to know that it's being used more than when I was there. Thank goodness. The point of this, of course, is that we're going to do a hypo in a second. The point of this is that we are talking about a world where you are starting with a client's position, which means you may need to do a lot of work to make it sound reasonable, right? So let's start here. This is the hypo I like. If you've sat through my presentation last year on this, I use the same hypo, so don't say anything. All right, so you get a text from your client. It says, as clients do, this text probably came at a ridiculous hour. Hey, can I get a tattoo? My case manager says no because I'm only 16 and it's illegal. Will you sign the papers for me? Right? Oh, geez. All right. So, all right, we're going to do a thing where we figure out what the position of the client is, right? We're going to ground ourselves in that based on this very limited hypo where you don't actually get to talk to the client. So this client clearly wants a tattoo and wants you to sign the papers, right? Okay. All right. Does anybody sign the papers? Just curious. Nah, you probably don't, right? So you'd first, right, investigate the law and the facts. Let's investigate the law first. It's down there at the bottom. Tattoos in Florida are legal for 16 and 17-year-olds. The case manager in this hypo is wrong, right? It is legal, but the kid's going to need a parent or legal guardian to sign off on it. That's not you, right? Unless you've adopted or taken that kid in, that is not you, and you shouldn't be their attorney if you've done those things, right? So you're going to need a case manager or somebody, maybe even a judge. I bet they take a judge signature to go into that place in the mall where they pierce the ears and do tattoos aren't the mall. That place on whatever road in your town has all the tattoo places, right? So you need the signature. Here's the hypo, right? Here's the difference. Do you do this? Are you going into court, based on the information I have here, are you going into court and filing a motion to have the court order the case management agency to sign the forms for the tattoo? No. I'm hearing no, right? I'm hearing no. You're changing their mind tomorrow? Oh, because they're a kid and they'll change their mind tomorrow, right? Well, they might, but that's their decision, right? Clear up until they get to the needle and it's scary and they run away, right? Right, that is the typical analysis that we as adults do, and we're going to talk about that. Let me add a fact in here and see if it changes your mind at all. So this client, this is a real story. This client, the tattoo he wanted was his mom and dad's name on his shoulder because they both died in car accidents a month before, and they had his name tattooed on their shoulders when he was born. Right? Oh, it's harder to say no to that. It's harder to say no to that. And something about the facts changed there, where morally now we want to fight for this kid. But as lawyers, if you felt the shift in your own thinking about it, as a lawyer, right, we're supposed to start with, I'm going to fight for you, and investigate it and figure out why, even before you ask the question, right? And so this is hard to do, especially with kids. It's hard to do because they'll change their mind. Guess what? Adults do too. Adults do too. How many divorces get filed and get dropped, right? Do you not file divorces? Of course you do, right? Partly because you bill for it, right? All right, so this right here is like the classic example of are we focused on the client? So there's this great article by Dean Co-Peters. It's actually from 1996, so these ideas are not new. The title of the article is at the bottom. It is The Role and Content of Best Interest in Client-Directed Lawyering for Children in Child Protective Proceedings. Whew, right? And Professor Co-Peters asks these questions about how we interact with our child clients, and really it comes down to, are we trying to understand the kid's point of view? Are we trying to please, or are we making sure they understand what's going on to the extent they can, right? And then the important part, are we trying to gratify adults on the case and in our lives, or are we trying to do what the client is asking us to do? I have found myself in weird situations where I'm like, oh my God, everyone's going to think I'm an idiot for going in and saying this, right? Because no adult would ever go into the world and ask for a kid to be able to do X, Y, or Z, right? If you're the lawyer, though, that's your job, right? Your job is to make childhood idiocy sound reasonable, right? That is it. And it's a tough job. It is a tough job.
So, Robert,
yeah.
So the tattoo example is easy.
Yeah, it is.
What about, I mean, I think I struggle, what about, can you talk a little bit about that concept in the context of our severely mentally ill kids who never want to go to residential treatment, but they are, you know, a suicide risk, a cutting risk, a safety risk. So can you talk about that?
Yeah, absolutely.
In that context?
Yes, and we will. And so fortunately the law helps you. Right? Remember, you owe an obligation to the court to bring a meritorious case, right? Attorneys are not spokespersons. They're not, right? You can go into court and repeat what your client told you. He wants to not go into residential. Great, where's your case, right? If all you did all day long was just repeat what clients told you to say, you are not a lawyer. Right? You have a huge ethical issue going on in your practice right there, if that's all you do. You have to build the case. And it can be the case that when you go to try to build it, it's not there. It's just not there, right? So the severe cutter, right? It may be the best case you have is, Your Honor, he just wants another chance. That's all you gotta do, right? The judge is gonna see right through that. You have no experts, you have no facts, they're severely cutting. Everybody else is presenting conflicting evidence that says your client probably is a risk of harm to self or others. Your client's going to residential, right? But if you stop the analysis for when you're building your case, and we'll talk about this, when you stop the analysis just at, I'm going to just go and repeat what they say, then you're not doing your job, right? There may come a point where the client wants you to say he shouldn't go to residential, and you in your heart of hearts know this is so dangerous, you cannot go in there as an adult human being and say this. What do? Withdraw. Yeah, hey?
You say, Your Honor, my client wishes.
Right, there's a lot of dodging that goes on, right? But ultimately, if you really can't do it, there's no one with a gun to your head, right? If you really can't do it, just withdraw. Just withdraw. They'll get another attorney or they won't, right? Don't go in and do something that you, at the end of the day, are gonna lose sleep over. But only do that as a last resort, right? Last resort, because we'll talk about this. I keep saying we'll talk about it because we will. The benefit of having an attorney is way more important probably than our own personal feelings about what we have to do sometimes. So you're not just a spokesperson. If you get in a bind, you can withdraw. Don't let a kid die on your watch, right? All right, attorneys make cases. They don't just say positions. So the Guardian Ad Litem program does best interest advocacy, and as part of that, they're required to inform the court when the kid's position is different or whatever the kid's position is. They put it down at the bottom of their JR reports. It's great, but that's not a case, right? It doesn't supplement or even replace what an attorney would do, which is build out the case. So an attorney looks at the law, looks at the facts, and tries to bring a moral argument for why not only is it legal and factually sound, but it's the right thing to do. Oh look, we're back to best interest lawyering, right? All lawyers do this. You're trying to not just convince, you're not just trying to convince the judge that it's legal and factually sound, you want to make the judge want to do it. That's effectively best interest lawyering, right? Different advocacy models focus on different things, different cases, right? If the law's not on your side, pound the facts. If the facts aren't on your side, pound the table. Is that what it is? I can't remember how it goes, right? So it's just that, right? So what we're going to be talking about is building these cases using experts so that we can highlight what we need to in these cases and bring more moral force and better advocacy positions and better counseling for our clients so that when we go into court, hopefully we feel better about what we're doing than what we did the first time the client told us the crazy idea. All right, so let's do our first hypo. You ready? All right, so this is the crazy auntie. You've all had a crazy auntie case. You have all had one. So the client lives in a foster home. She's doing great there, right? I'm sorry. Rewind. The client is not doing well in this hypo. She is not doing well in her foster home. She has an auntie she wants to live with. The auntie is crazy. She screams at everybody on the case, but she loves the kid, and the kid loves her, right? Home study after home study doesn't get done. You're not entirely sure why. You're pretty sure it's because of conflicts between the adults, right? Guardian ad litem is just not pursuing her as a placement. They've had it. They're done with this lady, right? But your client loves her. All right, what's your client's position? She wants to live with her favorite auntie. We don't get to get around that, right? Okay, what investigation do you do? That's what this whole thing is about, bringing in experts and doing factual investigations and having experts to testify and fact witnesses. It does require a home study. The home study hasn't been done, right? Our traditional kind of list of things we would do is we would come in and have the judge order the case manager to go out and do the home study, right? Right? Yeah?
I can do get funds for a PI and have a government background.
Okay. Do you do background checks?
I've easily got JAC to approve the PI.
Bingo. Right.
Will the JC pay for home study?
Well, for litigation purposes, right? So I will tell you, Jack and I have had this conversation. So I'm going to give you hypos. Jack, we're going to talk about later, has an obligation to object in a lot of cases, right? So we're friends with Jack today because they're here to help us with this, to let you know, what to expect. Will they pay for a home study? Not if DCF should do the home study, right? So if your motion just says I want a home study and you're trying to get payment for it, that's going to get objected to. You're going to go in front of a judge.
But the PI can go out and check out the home and take photos. I mean, you come in and you can present you can do
Right.
a pseudo-type home study. I mean, you can show the judge what you've got, and then the judge then orders the formal type home study.
Bingo. You can, and you, maybe not even a PI. There's licensed social workers out there that could do it as well. They can do an actual home study. They do them for adoption cases, right?
PI is not that expensive under
Right.
the JAC.
Right.
I mean, they are under the
Right.
JAC.
Right.
PIs are not that expensive.
There you go, and that's the point, right? So for a lot of us, the gut thing would be to order DCF to do the home study, right? Well, they've already not done the home study 3 or 4 times, right? Your motion for your own private home study is getting better and better and better because DCF is not doing, in this hypo at least, what they're supposed to be doing, right? And then from a litigation perspective, do you really want the home study being done by the case manager who doesn't like the lady? No, right? That is not what you want. That is bad litigation, right? So you want it done by your own person who can go in there and hopefully not have beef with this lady, right? Okay, so there was the crazy auntie. A couple of things that we're going to talk about a lot, which is attorneys are not magic. You don't know everything. You don't have to know everything. That's okay, right? That's okay. I'm giving you permission to not know everything. You are also not witnesses.
Bad thing if you are.
Yeah, it's a bad thing. Thank you. It is a bad thing if you're a witness, right? Lots of attorneys go out and do their own home assessments and all that. You want to go see the kid in context, that's important. Bring somebody with you to testify about what crazy thing. You don't know what you're going to see when you walk through the door, right? Attorneys are not witnesses. You can get help from friends. Let's do it. Here's the situation. The situation is that attorneys are not actually doing this. That's probably why you're here. So this is from Jack's, oh my gosh, when did we get this? It was about a month or 2 ago. I apologize for not putting the date. We got the list of payments that have been made. So the number of cases billed and the amount of the attorney's fees is actually going up. So, I mean, obviously there's a giant spike that's blank. That's pretty much the ones that came in when everybody converted their old ones to new ones, right? So we then have this steady increase. That's good. The number of attorneys unique attorneys actually participating in this is actually going down a little bit, and that's expected. There were some people that jumped on it and thought, oh, well, I represent parents, I can represent kids, and then found out it is not the same thing at all, right? And so it has gone down a little bit at a peak of 130-ish, down to, we're kind of like in the 90s now of unique attorneys per quarter. That's how I measured this. Okay, so there's 90 of us running around doing this. In any given quarter. They may not be the same 90 per each quarter. People bounce in and out. All right. Only 11 invoices that we could find were billed for non-flat fees. So that's the ones with the little one. If you look on the payment amounts, these were all the payment amounts. 1,800 of them were billed for $1,000, right? 700 were billed for, or 786 were billed for 2,000. There's only a few that have weird numbers, odd numbers there, right? So people aren't even really billing hourly for this for the most part. There may be some benefit to doing that. That's a different presentation. Let's see. Most of the appointments, in case you were curious, most of the appointments, I think I have a pointer here, most of the appointments come in for psych meds. Right? That's at least the amount of money being spent the most. So, I'm sorry, I said psych meds, but I meant developmental disabilities. So 1.1 million for developmental disabilities in 2017. The next one, which is about half that, a little over half that, psych meds. Yeah, well, I keep doing it all wrong, right? The next one down, psych meds and residential treatment, then trafficking, then skilled nursing facility, there you are, guys. Then unspecified, I don't know what they're doing. Who knows, right? Okay, so for the most part, it's developmental disabilities, which I've learned is just any kid who had educational neglect and the judge is worried, right? But whatever, I'll take the appointment.
Why do you think there was such a jump? Like the developmental disabilities, it's interesting how it, or do you know why it jumped so much?
Do we have any actual knowledge, not theories about this?
The order just fits. They're not going to specify. JC's going to categorize it, whatever.
Right. JAC doesn't look behind the order.
Yeah, we don't look.
So I don't know from this data why. I can break this number. I'm happy later to break it down and see if there's some region that's has a spike in developmental disability appointments. I know Tampa, for example, does a lot of psych med appointments compared to a lot of other places. Yeah.
In Seminole, we seem to see a lot of autistic.
Okay.
I get them all.
And are they all 3-year-olds that people are worried about because they're delayed? Or are these actually 16
Across the
autistic?
time.
Okay.
It really is. It's, my youngest one is 2 and the oldest one is aged out.
Okay. It is interesting. Guessing, judges worry about these kids a lot, right? Maybe that's it, I don't know. Okay, this is parents' invoices. We're just using this because this is the only data I had. This is parents' invoices. So number of invoices for attorney's fees. This is from 2016, 2017 fiscal year, right? So attorney fees for parents, 15,000 invoices for just attorney's fees, 113 for court reporters, 20 for witnesses, 8 for investigators, and then this other category, which is a little bit of everything. So what are they billing for? They're billing for themselves. All right, so here it is broken down. This is 2014 to 2017. Attorney's fees for parents was about 30 million. 250,000 on due process costs for a total of 0.82% being spent on the things we're talking about today. For kids attorneys over the same period, it's not apples and oranges for the fact that we're still ramping this program up during this period, but the numbers are pretty much the same, right? Attorneys just aren't spending that much money on this. We're not utilizing these resources. That's why we're doing this presentation, right? So, putting together the team. You ready? Here we go. I have no idea what's next. I hope it's something good. Oh yeah, why use experts? Why use them? I've given you some examples. The number one goal is so that you can have subject matter experts come in and help you with your advocacy and free you up to focus on the law, right? Between the two of you bouncing ideas off of each other in a nice, confidential, privileged way, hopefully you can do number two, which is craft better positions. So you can go in front of judges or help your client move to a better position so you can actually have better advocacy all around. I have found because we have experts in our clinic that the school pays for, just communicating with other experts, having your own in the room, having your own psychiatrist in the room to just help you communicate with another psychiatrist is invaluable sometimes, just invaluable. And also, of course, it insulates your win from appeal. Having your own expert testify, having some competing expert even just go blah, 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 right? If you win, suddenly there's right? Substantial competent evidence of whatever you wanted it to say, right? And so just from a litigation perspective, again, always have your own expert if you can, right? Could be that you can't find an expert to say what you want them to say, in which case you have a position problem, not an expert problem. All right, now, what is the legal standard for getting this expert paid for? It's mostly, it's different in a few places in the statute, but summing it all up, it's the expert or the witness or the whoever you're getting, the due process expense has to be reasonable and necessary. Reasonable and necessary. There are some appropriations caps on this as well that we don't really need to get into today, but really you're always coming back to reasonable and necessary. So is it reasonable and necessary to do a home study on the aunt if DCF has not yet even done a home study? No. From a litigation perspective, not reasonable or not necessary, right? DCF is supposed to statutorily do the home study. So they do it first, it comes out crazy, you're gonna fight it, you're gonna challenge it. Now it's suddenly at least necessary for you to get a competing home study so you can bring a case. Otherwise, you're stuck with the home study you got, right? All right, what is reasonable and necessary for child representation? We have no case law on this yet. No case law. There's some case law in the criminal defense, especially capital defense area, but nothing yet. So I encourage you guys all to go out and challenge, Jack determinations left and right. Let's build up a body of what's reasonable and necessary for kid appointments. I will say this criminal specialist investigations versus state from 2011 was a case in which a judge denied the appointment of a mitigation specialist in a capital case, and the judge was like, "There's no such thing as a mitigation specialist." JAC was not objecting, right? They're like, a mitigation specialist is just an investigator. They had no objection, but this particular judge had an objection, and so it went all the way up on appeal. The first DCA came back and said, "It's an investigator, what are you talking about?" But what they did say was useful is that the United States Supreme Court has said, look to the ABA standards, look to professional standards for what is reasonable and necessary. That is what you should be doing. So when the next slide will do that for kid representation, I will say be patient with Jack on this because they are learning our area of law in ways they have not yet, right? They are comfortable talking about parent representation to a large extent. I've had conversations with folks there where I feel I'm doing education for them so they can understand how we are different from guardians ad litem, how we're different from case managers, which is why I did the slides before. So to the extent you could explain that in your motion or in your request and your communications with them, that can go a long way. All right, so what does the ABA say for child representation? You go back to 1996-ish for their standards of practice for lawyers who represent children in abuse and neglect cases, and it's right in there. You're supposed to do your own investigations, right? To support independent investigation. Rely on the CPI's work, you can use it, right? But you're supposed to do your own independent investigation, which means witness interviews, getting out there, doing your own evaluations, everything, right? So the ABA is on your side. You can point to that. All right. So in doing these independent investigations, the statute, we're not in 39, you know that, right? We're in 29. So the statute does have a list of statutory services that are just kind of built into the statute. These things are going to be easy for Jack to say okay to if you're doing any of these. So court reporting and transcription, interpreters and translators, witnesses, including expert witnesses, mental health professionals, pretrial consultation fees, travel expenses, which we're not talking about today, but I put it on there for completeness. So if you're pulling for one of these, great, right? Jack's super comfortable with this. I'm not going to try to fight with the internet today. There is a due process vendor search on their website. This is the most practical, useful thing I will tell you if you did not know this. This is where you go. You can go and you can look for an expert. I think I blow it up. Yes, you can look for, whoa, Jesus. All right, you can look for an expert witness. You can find expert witnesses that they already have contracts with the JAC. Perfect, right? You go through, you call them, you say, have you ever done a dependency case? They tell you no. Have you ever done a family case? Yes, okay, close enough, come on, all right? You're gonna be looking for experts that have experience in child and family systems, that are sensitive to those types of issues. I bet the experts that you're looking for are there. You may have to do a little bit of calling to find somebody you know and trust, right? Okay, oh my God, we're doing it again. If you look over here, I mean, there's all kinds of things. Court reporters, interpreters, translators, investigators, mitigation specialists, they put it on the list. All right, process servers, sign language interpreters, there's tons of them. It goes on and on and on and on. Okay. I'm going to break it for the purposes of this presentation into these types. So testifying experts, consulting experts, investigators, interpreters, and then this litigation paraprofessionals. I will caution you on litigation paraprofessionals. That does not mean paralegal. JAC does not pay for your administrative overhead of running your office. We all know that, right? So you don't get to pay for, JAC will not pay for your paralegal's time. If you choose to hire a paralegal, that is your choice. But if you have to do a deposition, they will pay for the court reporter, right? Because that's part of the litigation, all right? I said it. All right, there we go. All right, so let's do the experts and consultants. So when you look on that list, they already have all of these on their list. They have subcategories on that dropdown. They have these child abuse and child sexual abuse experts. They're right there. Ta-da! Forensic pathologists, medical, physicians, neuropsychologists, nurses, pediatrics, pharmacologists, radiologists, all on the list. All right, you got that brittle bone, broken baby case. Ta-da! Do your own investigation on your kid. Right? Figure out if you agree with what DCF's people are saying. Right? Psychologists, mental health people, sex offender evals, ta-da, they're all there. Social workers are on the list. You can hire a social worker through Jack. And then there's this great category called other. I have no idea what they are. There's tons of names there. Call them, see what they do. All right. All right. I made this list. You could probably add a lot of things to this list. So by appointment type, developmental disabilities cases, you will probably, if you find yourself in litigation on the issues around your kids with developmental disabilities, you're probably going to need a psychologist. You're probably going to need a psychologist, right? You may even need a behavior analyst. You may need your own, right, to talk about what kind of interventions the placement could be doing that they're not doing that would help, decrease the behaviors. If they're not in a place that already has a behavior analyst, maybe they're in a place with a behavior analyst and that behavior analyst is crappy, right? Then you would get your own to come in and say it's a crappy behavior analyst, this should be in a different place. Residential treatment centers, same list, though I did add social workers on there. I think social workers could go on all of them. We'll talk more about social workers in a little bit. Psych meds, same list except psychiatrists, and pharmacist was on the list. Ooh, that's interesting. Pharmacist was on the list. Pharmacy experts to talk about drug interactions and all those things. Bring that person in, right? Next time you want to fight a psych med motion. Human trafficking, psychologists, behavior analysts, social workers are invaluable because a lot of those kids have, we're going to talk about, a lot of access to personality stuff going on. It can be very difficult to work with. So having that extra manpower to kind of help counsel that client can be very, very useful. All right. And then these for just any case, right? Forget the type. Education specialists. We're going to have a hypo on this in a second, but you can bring in an education specialist to help you craft the ideal IEP, because I will tell you, the law does not tell me how to do that, right? It just tells me the process. It doesn't tell me the substance. Medical experts, therapeutic, placement experts as well. You get all those things. There's the school hypo. All right, the stonewalling school. Oh my gosh, we've all lived this, right? Your client's got a developmental disability, struggling in school. He doesn't want to go in there anymore because he's frustrated, right? He's frustrated because of the way they treat him, so it gives you ethically some room to work. Let me try to make it better so you'll stay in school. Not you're going into court and saying, my kid doesn't want to go to school anymore, he has that right, right? So we're at the process of trying to counsel through and work through this. So there have been all these IEP meetings and the school keeps telling you we're doing everything we can. We're doing everything we can, and we've hit the wall. Okay, how would an expert help in this, right? There are people already in a lot of your communities that are specialists that are working privately, at least, to do this work for families that can afford it. Call them, right? They are probably not on the JAC website. I'm 100% sure they're not on the vendor search, but they need to sign a contract, they need to be qualified, they need to be licensed in some way, or you need to get a judge to approve it, and you could get them covered. I think some of you have actually done this, yes? Mm-hmm. Yep, so when we get to the process, you're going to need a quote, an hourly quote, and an estimated maximum amount that's authorized. And then Jack has a lot of, there's some statutory lists of rates that they have to pay, right, for certain things. But when you're bringing in somebody kind of off the list, then you get into a court, you're going to have a court hearing on this one, unless you get an agreement. For those of you who have done it with educational experts, was it a court hearing or agreement with Jack? Anybody? Agreement. I have agreement and court hearing. Okay, so we've had it a little bit both. Probably the order that you guys went in probably affected that. So Bring that person. Bring them to the IEP meeting. Have an educational specialist sitting next to you, an expert witness. IEP meetings are pre-litigation meetings. You know that, right? Right? You are crafting a document that is going to be enforceable against that school. Either they're going to do the things that are in that document and everybody's going to cheer, or they're not, and you're going to sue them in a due process hearing, right? So it's a pre-litigation meeting. You're getting ready for the litigation. Having an expert there to help you craft the best IEP you can for your client seems like a reasonable litigation expense to me. All right, I facepalm here. Lawyers, you don't have to know everything. Okay? It's okay. The law on education, on due process and school discipline and all that tells you how the process is supposed to work. You guys are experts on process. That's what you trained your entire lives to do and have done your whole careers. And that's what you can focus on. Bring in a subject matter expert to tell you what a kid who has a specific learning disorder in communication needs as her goals on her IEP, right? Her measurable goals. There's no way, the law doesn't tell you that. So bring these people in, let them help you, everything will be so much better. All right, you ready? Professional help, here we go. Now, I say bring people in. We need to acknowledge that there are not, I don't want to say risks, there are considerations that have to be made when making this choice, right? Because not all professionals operate in the same way lawyers do. So you got the 16-year-old client, this is the hypo, right? With a severe mood disorder. Lots of comments from this client about self-harm in the past. Everyone knows she's a cutter, etc. You meet her and you notice cutting again. She mentions to you she's experiencing higher rates of suicidal ideation. She doesn't want this information shared at all with anybody. She's afraid that if you tell people or it gets out that she's been having these feelings, they're going to kick her out of the current placement that she's in, where she, at least on the surface, appears to be doing well, and she likes, but she's having these thoughts. You counsel her to disclose, and making this harder. You counsel her to disclose. She says, not yet. Not yet, not yet, not yet. You tell her it could prevent bigger problems. She says, not yet. All right. You think, okay, maybe I can bring in a social worker to help. Pros and cons. Any pros? Yeah. Yeah.
Well, I had a con because I think that it would be a mandatory reporting. When I try to bake her accurate and different things like that.
Just like a lawyer, right to the cons. Right? All right, so.
She might feel comfortable with this person. They may start recommend some therapeutic treatment and we can deal with the ideation.
Right, we get a chance to have professional intervention within the attorney-client relationship. She won't let you tell other people. Fine, I can bring a therapist in to talk to you now, right? My counseling as a lawyer, again, I'm not magic, right? I counsel people about the law all the time. It is not the most therapeutic process, right? Bringing in a social worker to come in and actually not do therapy, but at least help her work through this and why we should disclose and do it in a way that's therapeutically informed could be super useful, right? Any other pros before we get to the cons? There's a whole slide on the cons. All right, that seems to be the biggest one. All right, I like that. I like that pro. The cons. The cons are therapists operate under a different ethical framework and social workers under a different ethical framework than we do. This is the #1 tension that often prevents lawyers from bringing in social workers and mental health professionals. And what I'm here to tell you is that it shouldn't. It doesn't have to. It doesn't have to. So here are the two. Here, it's not complete, but it'll work for our conversation here. Here are the two reporting requirements. So lawyers must disclose if their clients are going, well, to prevent their client from committing a crime. This client is not committing a crime. So cutting, not a crime, as far as I know. If anybody knows differently, let me know afterwards. Or to prevent a death or substantial bodily harm to another. There are ethics opinions on this. Florida has made the choice. The model rules say to self or others. Florida has made the choice to say to another. It's an intentional choice. It's crappy for lawyers, right? Your client comes in and says, I'm suicidal, I want to hurt myself. Your job is to counsel them as a lawyer, not call it in, right, under these rules. Do you call it in? That's up to you, your own ethical obligations, your own ethical decision. But that says another, right? So, yikes. Therapists may disclose when, oh, this is much wordier. All right, when there is a clear and immediate probability of physical harm to the patient or client, to other individuals, or to society. I don't know what that means. I have no idea what that means. What I do know, because I'm a lawyer, is clear and immediate probability of physical harm, not economic, not all kinds of other stuff, but physical harm, and clear and immediate probability, right? So the kid that comes in and says, yeah, I'm having a lot of suicidal ideations. Okay, that social worker has some wiggle room to work with that person until they think it's clear and immediate, right? But there is going to come a point where, whoa, we're no longer at ideation, we're at a plan, and the social worker is going to feel triggered to actually call this in, right? Now, who do they call it into? Potential victim, if they're going to harm somebody else, appropriate family member, law enforcement, et cetera. They don't get to publish it in the newspaper. They have to call the right person. There are cases where therapists, psychotherapists, psychiatrists, other people have gotten sued for not calling it in, and those lawsuits were permitted to go forward because that says may, right? And they also have an obligation to follow their professional standards of care. So may means you can do it, right? And that means if you don't do it, maybe you were negligent as a therapist. So the thing to know is that you're bringing a person with a different reporting requirement inside of the attorney-client relationship, right? Now, can you not do that? Is that ridiculous? You would never do it? Maybe that's your professional judgment. If you're going to do it, though, what do? You just give the client full disclosure. Full disclosure. So this is Maxine, that's the name of our therapist. Maxine has a different set of ethical requirements than we do. If you let her know that you're going to hurt yourself or others, she may have to report that. Are you comfortable working with Maxine so that we don't have to let everybody else know what's going on, and maybe we can work through this together? Client says yes, client says no. I like to get it in writing because you never know. That's for the client that can consent. You have different ethical issues if it's a client who can't. Questions? Thoughts? It works. It works. There's University of Illinois. There's a clinic at the University of Illinois that pioneered this, working with social workers. There's been a lot of writing on it. We've done it for 20 years at our clinic, and never once have we found ourselves playing chicken with the social worker. Well, playing chicken with the social worker on a mandatory reporting obligation where the client didn't go ahead and tell everybody anyway, right? Because if they told you, I mean, they're kids, right? They told everybody. Or the client didn't tell, or the client wasn't willing to disclose, or the situation didn't resolve itself, right? So we've never gotten to that point. What we tell our social worker is, if you do get in this situation, do not call it in. Please, just as a professional courtesy, don't call it in without talking to us first, right? Let us know so we can try to work through it. Because their standards say clear and immediate probability. So that usually gives them a lot of wiggle room. So a couple of things to note. All right, so don't use your social worker if you get one for all of your client communication, right? Because that means your client never gets an opportunity to tell you things that may implicate the social worker's obligation to report, which gets you back into the same problem that we're trying to avoid by having the privilege and the confidentiality. 2 or 3, I guess, I don't know what. Retain, oh my gosh, an experienced social worker, not a hair trigger, thin-skinned social worker that's going to report everything, right? You need a person with experience who knows how to work through a crisis. We handle a lot of crises, right? And then you're always counseling for the client to disclose, right? I mean, like almost always, right? If they're having all these problems and all these issues, and you can solve the problem with intervention and everything like that, 99 times out of 100, you yourself are also doing the same counseling, which usually resolves the tension right there. Thoughts?
So I have a question, Robert.
Yeah.
I'm just curious. Does your clinic employ the social worker like through a grant, or
Yeah.
do you pay the social worker through the JAC all the time?
Our social workers through a grant. JAC, of course, we're going to talk about getting it appointed. JAC is going to need a reason that it's reasonable and necessary on that case. I think you could build a case that with specific clients and specific fact patterns, a social worker to consult with you about the litigation would be reasonable and necessary, especially if you're attacking DCF social work, right? Which sounds easy to do, but it is nice to have your own expert to do it. Yeah. Okay, so that was social workers. That's usually the most controversial one, right? All right. Investigators on the JAC list: cell phone, cellular tower mapping, GPS, computer experts, social media experts. Awesome. All right. Witness interviewing it's on the JAC list. Those are the ones. They also just have straight up private investigators. I don't know why I didn't list that. Private investigators is just like a whole category, and there's like 100 of them. More than there's thousands of them. Home visits, we talked about that. That may be a thing you would want to use investigators for, or social workers kind of doing a dual function role. And agency monitoring. Agency monitoring, huh. All right, why use investigators? She's cute, I found her on the internet too. All right, why use investigators? Because you literally can't be everywhere you need to be at the same time. You can't. You yourself cannot monitor the home visit on one side of your city while you're supposed to be at the school meeting on another side of the city, while you're doing this, while you're doing that. It's impossible to schedule. It's impossible to take enough cases, right, to make it financially feasible and schedule everything you have to do out in the community to do this job. This is probably one of the #1 reasons that a lot of the parents' attorneys bailed. And I don't blame them, because in their parents' caseload, where they spend most of their lives? In court, right? This job requires you to be out in the community in ways that that job does not. So I get it. So investigators or social workers functioning as investigators are really good to duplicate your, multiply you throughout the community. You don't have to rely on your clients and credibility, because your client probably has limited credibility to begin with. This was a huge shock moving from guardian ad litem, where, oh my gosh, everybody loves them, right? They're volunteers, they're great, everything they say is gospel, right? And then you move to a kid client, and everything is suspect, everything, right? Some motive, some this, some that, oh, well, you just haven't been on the case long enough, that sort of thing. You don't have to rely on your client's credibility. You bring in a professional who's actually done the investigation and have them testify instead. Ta-da, credibility, not an issue. And then, as I said before, you can't testify, even though I know you do all the time, because I have been in JR hearings with us, right? We do it all the time. We proffer lots of things as officers of the court that are very factual. Yeah.
That last screen that you had,
Mm-hmm.
where did you get that?
I realize that it's a hybrid. The top line is one of the three of the drop-down categories from the JAC website. So they have experts already on their list to do the top things. The 2, 3, and 4 were actually my ideas about ways you could use experts.
Okay, so when I drop down investigators, it's not going to.
It's not going to say home visits.
It's not going to say agency monitoring.
It's not going to say agency monitor either. I apologize about that. That slide is messy. Thank you. I appreciate that.
My investigator list as a line item, agency monitoring, will it get kicked back?
Yeah. If it just says that, yes, you're going to explain why is it reasonable and necessary. We're going to have a hypo on this in a second. What are you monitoring that needs an actual investigator? Now, investigator versus social worker, right? Social worker is a licensed social worker. An investigator, probably former law enforcement that loves sitting in cars for long periods of time and doing nothing, right? The investigators go out and interview people and then come back and report. They're really good at interviewing. But maybe you want a social worker to do the social worky interviews and the investigators to do the hit and run interview. It's your choice on who you actually use for these things.
My next question was, how would you envision utilizing the agency monitoring? But I guess we're going to get to that.
Let's do it. Here we go. 13-year-old client, removed from his home due to neglect case, desperately wants to go home, right? His mother's working through a case plan, but has recently been reported to miss her visits. She's very inconsistent with the visits. The mother takes a bus to the visit and claims the case manager cancels the visits if she's even 5 minutes late. Cancels them, right? The court has threatened to order DCF to file the TPR if this mother doesn't get more. We've been in this situation, right? We've heard this scenario. If she can't show up for her kid on time, she can't have a kid. All right, well, you take the bus, right? Okay, fine. Your client's like, but she's not that late. She's not late. They're being unreasonable, right? You put your client on the stand, you put the mother on the stand, you put the case manager on the stand. Credibility gap, huge, right? Fine. Hire an investigator to sit in the agency parking lot. Right? They love to sit in cars. This is what they do. They sit in the agency parking lot, and they just mark license plates as they come in and out. Case manager showed up at this time, case manager left at this time. You know when the visits are, so you're only getting them for like that little gap right around, right? Have a whole log, you have a neutral independent person, take some pictures of her dragging the kid out of the case management office, the kid grabbing the door frames and screaming and crying and not wanting to go. Great, right? Perfect. There you go. Congratulations. You now have evidence that is not subject to the credibility gap, right? That's how I use them. Yeah. I have. Yeah. All right, there was the kid desperately wants to go home. That was the position. We didn't do that. How about this one? This is another expert case. The reluctant reunification, 4-year-old nonverbal client, developmental disabilities. She cannot tell you anything. She's not a fact witness for you at all. She's removed from her home due to domestic violence between the mother and the mother's boyfriend. She's currently living in a foster home. She's doing well there. Right, great. Mom has a reunification case plan. Your client's very bonded to her mother. I've made it hard. She lights up when they're together, runs to her arms when she sees her. There's no doubt in your mind that she loves her mother and probably wants to go home. Right? The client cries inconsolably anytime anybody mentions the mother's boyfriend. Make that easy too. She does not want to go anywhere near the mother's boyfriend. What's the position? There you go. She loves her mother, hates the boyfriend. If she's going home, right, your position is she's going home, right? The law says she goes home what? If it's safe. Right? You have an obligation to the court to not just say my client wants to go home and stop, but to actually prove to the court that it is safe. Right? This is the important part. So you have to prove it's safe. How are you going to do that? Well, you're going to have to investigate. How would you do it?
Check and see if the boyfriend's around.
Check and see. Are you going to go out? Right? Partly because he's crazy. You probably don't want to do that. But also, you can't testify. So who do you send? Your client? She's 4. You can't. You rely on case manager guardian ad litem check-ins. That's part of your evidence. Do you rely on it? Not according to the ABA standards. What do? Get an investigator, have him or her sit in a car in front of the mother's house on random times, during the weekend, during the day, check to see if the boyfriend's around. Find out where the boyfriend works, stop by there every once in a while, make sure mom's not dropping off lunch, right? Will it ever be perfect? Is it easy to prove a negative? No, it's not easy to prove a negative. Now, what happens when you find the boyfriend, right? Your client wants to go home. Now you have an ethical issue, right? You have evidence that contradicts your client's position. You have to counsel your client, who, by the way, is nonverbal, right? But you also have an obligation to the court to present a case that, right, is meritorious. If you know it's not safe, and the kid wants to go home, you have an ethical decision to make at that moment. Are you going to go into court and say she should go home knowing that the legal standard is it's safe and you are implicitly saying it's safe? Or are you going to withdraw? Or are you going to try to counsel your client, put her into play therapy? Or are you going to disclose this? It may actually be consistent with her position to even disclose it, right? You need to get him out of there to make it a home she wants to go to. This is the thought process. Okay, so hire an investigator, have them sit out in front of the house, follow the mom around a little bit. Have I done this? Yes. Yes, we have. Did we find anything? Once we did, we got these great videos of her coming in and out of the boyfriend's apartment, her getting dropped off for her visits by the boyfriend 3 blocks away and walking and trying to look as sweaty as she could by the time she got to the agency office. So in that case, we found lots of things. In another case, we followed this lady around for 2 months, found nothing. Nothing, right? Investigator did a trash pull, right? She threw her trash away, did a trash pull, nothing, right? No love letters from him, no nothing. Shows up at her office, nothing, right? That made me feel better about the reunification. Made me feel a lot better about the reunification, right? Okay. All right, here's the deal. You cannot go crazy with this. I know it is super exciting. You can't. Okay, let me give you another hypo from another case. The father has sexually assaulted your client, a young girl, right? You know he's a pedophile. In your heart of hearts, you know he's a pedophile. The proof of the case is going all over the place. You can't prove it. You don't know what to do. So what are you going to do? Oh, I have a great idea. I'll hire an investigator to pretend to be a 12-year-old girl on the internet, right? And then what will we do? Well, to catch a predator, we'll get him. We're going to get him, right? Why can you not do this? Oh man, it would be so much fun, but you cannot do it, right? You can't do it because you can't use a person to violate the rules of professional conduct for you. Right? You can't do it vicariously through somebody else. And why can't you do that particular thing? Because, well, one, the father is a party in your case, probably represented, right? So you would be communicating through a third party to a represented party. Not good. 2, you can't use deceit or fraud, right? The professional rule of conduct 4-4.1 says you can't do that. It does create, this drives me nuts. It does create an exception for prosecutors, criminal prosecutors. Overseeing sting operations. Why do they get an exception, right? And criminal defense attorneys don't, or we don't, right? Seems like everybody should get the exception if they do, but okay, fine. You can't direct them, I think I already did that, to communicate with represented parties, even if they're not represented. You cannot present yourself as a disinterested party to an unrepresented party. Right? So your investigator couldn't even go up to the dad or be on the internet with this person claiming to be a random 12-year-old girl, because that would violate the rules, right? There's just no way around it, right? Fake social media profiles, I'll go ahead and throw this in here. You're not allowed to do that. So if you're doing that, please stop. You cannot reach out to represented parties or other people through fake social media profiles. What you should do instead is create a friendly profile with your big smiling picture on it and friend them. Right, if you're doing the witness investigation, right, friend them as you, right? Say all of it. I'm communicating with you solely to get information about the case. Do you still want to talk to me? Most people just accept them before they even know what they're doing, right? Were you disingenuous or deceitful or fraud? No, right? You wouldn't want to do that because you can't testify, but your investigator, social media expert probably could. Also, I went ahead and threw in there, again for completeness, Florida is a two-party state for recordings, right? Can you wire your kid for sound and send him into the abusive foster home? Probably not, right? There's questions about, does a foster parent have a reasonable expectation of privacy, right, in interacting with a foster kid? I don't know. That really hasn't been litigated. I think you're in dangerous ground if you're wiring your kid for sound. Yeah.
I have this come up in injunction court a lot.
Mm-hmm.
Even when we raise it, the judge always wants to hear the recording.
Interesting.
Always. And so I don't know if you've had that experience.
That there's sexual abuse cases. I can't think of the name of it right now. It was first DCA, right? Sexual abuse. The kid said, he's been sexually abusing me, I'm going to record it. She recorded it. It was evidence in the trial, in the criminal case. The trial or conviction got reversed, right? It's dangerous ground if people are litigating it fully. I don't know the context of how fully it's being litigated after that moment. The judges should not be listening to it, truthfully. Maybe there should be an exception, but there isn't. All right, so we're not going to be doing any to catch a predator stuff, right? Right? We're going to stay within the bounds of the law, right? If you find yourself in this situation, you probably want to take a breather and consult with somebody who does more investigations. There's another exception on here about interacting with employees of an organization. So the rules say you can't interact as a lawyer, can't interact with a represented party. What about case managers, right? Yeah, they're not represented, they're subcontractors, or they are. I've certainly had case managers, general counsels at individual agencies try to shut me down on talking to their employees. But they're not, they're represented, but they're not a party. I don't know, it gets murky. There is an exception for talking to, so if you're suing McDonald's, does that mean you can never go into McDonald's again? No, right? You can interact with employees. Does that mean you can't investigate McDonald's behavior? No, you actually can. You can send out 100 testers to stores around the country as long as the people you're talking to cannot bind the company. That's usually the kind of rule of thumb. They can't bind the company. Their actions are the thing you're investigating. They're not binding the company by their words or their positions in any way. Again, if you're doing this, you're in shaky territory, and you should really think it through very carefully to make sure it's done in an appropriate way. It can be a lot of fun, but don't get in trouble. All right, goodbye. All right, so, all right, we got through the investigators. Those are super fun. You should do them. How am I on time? I just freaked out. 5 minutes. Okay, we're going to do it. So, no, really? Okay, so interpreters, client interaction specialists. We're going to skip through this really quickly. Can you bring in a social worker to help you with client interactions? Yes, but you have to justify it. Jack is not going to pay for a person to talk to your client for you. Just keep that in mind. All right, so you're going to have to say they have a disability, that needs extra counseling, we need guidance, they call 20 times a day, and it basically becomes like them speaking a different language, right? I'll give that. What does the ABA say? The ABA actually says the exact same thing. The child's attorney should work with social workers and other professionals to assess the child's developmental abilities to facilitate communication. So you've got the ABA on your side for that as well. You always have to make the distinction between whether this expert is going to be a testifying expert or a consulting, or a testifying witness or a consulting expert. You can look through that. at your leisure. The second you intend to put them on the stand, they become open for cross-examination, and all their notes can be up for grabs. So it becomes ethically tricky and strategically tricky about whether once a person's your expert or your internal defense expert, you really want to open them up. Maybe you want to bring in a second forensic to do the second evaluation and then have that person testify. All right, so here we go. Here's our team. Social worker, you're probably going to need one of those, both for investigations and for just making sure DCF's doing their job right. Educational expert, almost always. Probably a psychologist or a licensed mental health counselor, and maybe an investigator. You do have to justify it in every case. So I can do this in 3 minutes. You ready? I'm not going to teach you how to do the billing directly because JAC has a fantastically complicated flow chart to tell you how to do it. And if you just follow it, you will be fine. So first you read the flow chart. Then you read their PowerPoint, which tells you the step-by-steps, right? But here's what you do. It's a motion and a proposed order. Right? I'm committing to you personally right now, if you email me at any point over the next 10 years, I will send you a blank one that you can just change out the stuff for. Right? It's things that they've already accepted, so I will do that for you. You send the motion and proposed order to JAC, you wait for their response. They will either say no objection or they will object. Okay, fine. You then either submit it as agreed to the judge and get it signed, or you set it for a hearing. You then send the signed order to JAC, and guess whose obligation it is to do everything after that? Your expert. Right? You will occasionally get this email from JAC saying your expert has submitted an invoice. Will you please approve it? Right? You look, you see, is this stuff they actually did? And then you click the box and I think put your initials in or something like that, and you're done. You do that once every month or so when your expert bills. That's it. As we talked about a lot, the motion has to include an explanation about why it's necessary. It has to have a maximum cost, good faith estimate of the maximum cost, and it has to have a rate. So it can't say $1 million, no rate, okay, flat fee, what? And you can generally only get one expert per subject matter, but there are exceptions to that that we don't need to get into. All right, here's a sample motion. I think I make it bigger. Ooh, yep, makes it bigger. This is an investigative motion. What did this investigator have to do? Locate the biological father, do inquiries on commercial databases, locate certified documents, appearances to attend meetings and provide testimony, conducting any other yet to be determined investigative services as may deem necessary in the interest of this matter. The 8 paragraphs before this were background of the case about why it was reasonable and necessary to get an investigator in this case. I think this was one of the monitoring the father-boyfriend cases for domestic violence, like sitting outside of the house. Yeah.
Is the actual motion confidential if you're asking to see the father?
Yes. Great question. Oh my gosh. All right, so maybe. And the reason I say maybe is because most judges will sign it ex parte and seal it. That's been my experience and other people's experiences. Not every judge. And in the first DCA, you guys are having an issue right now where this issue came up in the criminal context. And even though judges had been signing them and sealing them separately for years, a new judge or somebody said one day, you know what, there's actually nothing in the rules that allow me to seal it. Meh. And they just didn't. Set it for a hearing, notified everybody, all of that. A few of you have told me stories about JAs and judges and clerks and other people sending out the motion to everybody to see if it's agreed. Right? It's not between them and you. It's between JAC as a representative of the state and you, right? So, so it should be sealed. You would want to talk to your clerk or your JA beforehand and handle it carefully because it could, in fact, disclose a lot of information that you did not intend to disclose. I know in Miami, the JAs in general are sealing them. I think they get sent over to the administrative judge. I'm not really sure. Yeah. Okay. The alternative is you can actually, and this is not a good alternative, but you can front the costs for this out of your pocket and then ask for reimbursement later. But remember, there is a risk that you will not get reimbursed if it is found not reasonable and necessary. So yeah.
I'm going to ask the timing. I mean, it just seems to me whenever I need this, I need it quickly.
Right. The turnaround for Jack is actually pretty fast on these. Like 2 days tops.
But then your court.
Well, it's up to your judge at that point. Yep. So you do have an alternative for front costs. I don't recommend it if you can avoid it, but it's there. All right. When Jack objects, breathe. It's not personal. They're just asking the court to review. Administrative stuff is not billable, and nothing DCF is supposed to provide is billable. Right? As soon as DCF knows that you have a pot of money you can play with, guess what happens? They want you to pay for everything, right? Jack will not do it, and Jack is going to hold their ground on this. They do, and they do it firmly. They do not pay for initial evaluations. They do not pay for home studies DCF should be doing. They do not pay for all these things that DCF should be doing. And they're very good about making, and you don't want to be in that situation where DCF is telling you to pay for everything. It's more paperwork for you, right? All right, yeah, I got through it. All right, here is my contact information. Right, I again am making a personal promise to you that I will walk you through any of these you want to do. I want to get the number from 0.8% up to a whopping 1% by the end of the year. Can we do that? Let's do that. Everybody go out, pick a case, find the next a thing you need an investigator for. Bring an expert to an IEP meeting. I don't care what you do. Let's do it together. Thank you very much for coming. Bye.